University of Pennsylvania professor Sarah Beringer Gordon. The Spirit of the Law is her most recent book. What do you mean when you talk about the old constitutional world and the new constitutional world when it comes to religion?
Well, for most of our nation's history, it was the states rather than the federal government that controlled access to religious worship, the rights of religious organizations, and so on. And in the early decades of the 20th century, that began to shift as the Supreme Court applied the national constitutional establishment and free exercise clauses of the First Amendment against the states, sort of centralizing debates about religion.
But if the states had the control, we had it written into our Constitution, freedom of religion.
We did indeed, but the First Amendment begins, Congress shall enact no law. So it was addressed only to the national government.
Were there restrictions by different states on religion?
Oh, yes, there were. Several states had religious establishments. Most states limited the amount of property a religious organization could own. Some taxed religious property. Others banned given groups' practices. I'm thinking, for example, eventually of various states in the Southwest banning polygamy, for example.
So when it came to Massachusetts, talk about Massachusetts or Pennsylvania, we're here in Pennsylvania, as a case study of states regulating religion.
Sure. Pennsylvania, for example, had an active blasphemy law, which we would now think of as starkly unconstitutional. And the last case that was brought, the last criminal prosecution under blasphemy law was actually brought in the early 1970s, kind of by accident, against someone who had a sign in his window saying something like, "Wanted radical carpenter, speaks to crowds, preaching peace." And of course, this person meant Jesus, but someone walking past thought of it as blasphemous and complained. The American Civil Liberties Union got involved pretty quickly, and the prosecution was dropped. More recently, a film company owner tried to name his company I Choose Hell Productions, and was denied incorporation under the state's incorporation laws because it was a blasphemous title for the company. That too eventually was dismissed.
Professor Gordon, why did it start to change in the early 20th century?
I think for several different reasons. One especially was the growth of the federal government in the New Deal era. The other really was that the embrace of migration and pluralism, immigration began to cease a little bit after the restrictive immigration acts of the early 20th century. And then the New Deal forced so many people onto the move, looking for work, having much greater contact with government, and the expansion of government power really highlighted the friction between a bigger government and the lives of believers. So there was a lot more attention.
You write about the Salvation Army and the Spirit of the Law. What's the role of the Salvation Army in changing religious laws in America, I guess?
Well, the Salvation Army, which many people don't realize, is an evangelical religious group, not just a group that rings bells outside department stores in the Christmas season. The Salvation Army believed in what they called the Cathedral of the Open Air, and would go into areas, especially impoverished areas, and have parades and make lots of noise with brass bands and cymbals and loud preaching, trying to attract especially the urban poor back into religious life. This came up against requirements of many cities that any parade be permitted, for example, And the Salvation Army made it a practice not to apply for permits and to be arrested, often playing their instruments on the way into the cell, and challenging these laws as anti-religious. And they won a lot of them. They also lost a lot of them. So they kind of destabilized the law of the states by challenging these restrictions. They never really made it to the Supreme Court of the United States, though, because the states were still in power.
Professor Gordon, when did the first major religious case come before the Supreme Court?
Cases from the federal territories had come in the 19th century via, especially Utah, questions of polygamy. But from the states, the really major cases made it to the Supreme Court in the late 1930s and early 1940s, really that New Deal era. And they tended not so much to be the Salvation Army, but the Jehovah's Witnesses, who also caused a lot of trouble.
And what was one of those cases? Walk us through it.
Well, a very interesting case called Cantwell against Connecticut involved a group of witnesses who had gone into a Catholic neighborhood in New Haven on a Sunday morning and began playing anti-Catholic records on portable phonographs and distributing literature. And they were arrested for disturbing the peace and preaching without a permit, and appealed their case all the way to the Supreme Court, which said that because Connecticut said, well, individual city administrators would decide what a valid program was for religious organizations and would allow them or not onto the streets, they said that allows too much discretion by the state government. And they applied for the first time part of that First Amendment, this time the Free Exercise Clause, as against the state of Connecticut, and overturned their law that allowed city officials to license or not as they saw fit.
And did that lead to any nationwide movements, or was it a well-publicized case at the time?
It was a relatively well-publicized case. The really big movements came when Jehovah's Witnesses, again, challenged laws requiring school children to salute the flag every morning, to say the Pledge of Allegiance. And at first they lost when they got to the Supreme Court. And in 1940 they lost in a big case that got a lot of attention. And after that, violence broke out against witnesses all across the country. And 3 years later, the Supreme Court changed its mind and said, you know, we may be interested in patriotism and national unity, but not by beating up school children.
And so today, our school children, because most classes begin with the Pledge of Allegiance.
They do indeed.
If a child wants to sit during that, can a child sit legally?
Indeed, they are constitutionally protected in their right not to have to say the Pledge of Allegiance. Yes.
The spirit of the law, Tim and Beverly LaHaye. Mm-hmm. Who are they, and why do they occupy a good portion of your book?
Tim and Beverly LaHaye are less well known than they should be. They actually were involved in very important religious movements from the 1960s through the very late 1990s. They were part of a resurgent evangelical culture. They, like so many other Southern evangelicals, migrated to California, set up megachurches, educational institutions, and eventually became deeply involved in politics. Beverly LaHaye, who is a particular interest of mine in this book, founded a group called Concerned Women for America, which still claims to be the largest women's political organization in the United States. And she based her organization on 5 spiritual principles: the Bible, the family, patriotism, the sanctity of marriage, the sanctity of life. And she began to litigate, arguing that religious parents should have more control, for example, over what their children were taught in school, arguing that the ERA, the Equal Rights Amendment for women, was a violation of the fundamental order of things, and winning many of these cases.
Did you interview her for your book?
I did not. She actually lives in seclusion now. She retired about almost 15 years ago now, and lives in California again.
Somebody you would have liked to talk to?
I would very much like to talk to her. And one of the things that I think is really important is that an organization like hers